Section 1, Rule 132, Examination to be done in open court. The, uh, ex- the examination of witnesses presented in a trial or hearing shall be done in a open court, and under oath of affirmation unless the witness is incapacitated to speak, or the question calls for a different mode of answer. The answers of the witness shall be given orally. Section 2, Rule 132. Proceeding to be recorded. The entire proceedings of a trial or hearing, including the questions propounded to a witness and his answers thereto, the statements made by the judge or any other of the parties, counsel, or witnesses with reference to the case, shall be recorded by means of shorthand or stenotype by other means of recording found suitable by the court. Section 3, Rule 132, Rights and Obligation of a Witness. A witness must answer questions although his answers may tend to establish a claim against him. However, it is the right of a witness. Number 1. To be protected from irrelevant, improper, or insulting questions, and from harsh or insulting demeanor. Number 2. Not to be detained longer than the interest of justice required. Number 3. Not to be examined except only as to matters permitted to the issue. Number 4. Not to give an answer which will tend to subject him to a penalty for an offense unless otherwise provided by law. Or number 5. Not to give an answer which will tend to degrade his reputation unless it to be the very fact at issue, or to a fact from which the fact in issue would be presumed, but a witness must answer to the fact to his previous final conviction for an offense. Section 4, Rule 132, Order in the examination of an individual witness. The order in which an individual witness may be examined is as follows: A. Direct examination by proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponents. D. Cross-examination by the opponent. Section 1, Rule 133. Preponderance of evidence. How determined? In civil cases, the party having the burden of proof must establish his case by preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issues involves lies, the court may consider all the facts and circumstances of the case, the witness' manners of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility, so far as the same so far as the same way same may uh same may also considered same may wait lang sorry, legitimately appears upon the trial. The court may also consider the number of witnesses through the preponderance is not necessarily with the greater number. Section 2, Rule 133, Proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree or proof as excluding possibility of error produces absolute certainty. Moral certainty only is required, or that degree or of proof which produces conviction in an unprejudiced mind. Section 3, Rule 133, Extrajudicial Confession. Not sufficient ground for conviction. as an extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence or corpus delicti. Section 4, Rule 133, Circumstantial Evidence. When sufficient circumstantial evidence is sufficient from conviction, if following: A. There is more than one circumstance. B. The fact from which the interference are derived are proven. And C. The combination of all circumstances is such as to produce a conviction beyond reasonable doubt.